Welcome to Background Checks 101, a help desk for employers. This help session will focus on EEOC's amended enforcement guidance, developing targeted screens and best practices. The intention of this video is to present guidance for users of consumer reports and is not a substitute for legal advice. Title VII of the Civil Rights Act prohibits employment discrimination based on race, color, religion, sex, and national origin. In April 2012, EEOC amended Title VII of the Civil Rights Act to further define employment discrimination based on race and national origin. The amendment focuses on the consideration of arrest and conviction records in making employment decisions. This session will only cover important highlights of the amendment since the document is 84 pages in length. In this session, we will talk about criminal histories and employment decisions, records of arrest and convictions that may cause disparate treatment, neutral screening policies that may cause disparate impact, what EEOC wants employers to consider, ban the box and best practices. An employer's use of an individual's criminal history in making employment decisions may in some instances violate the prohibition against employment discrimination under Title VII of the Civil Rights Act. Arrest and incarceration rates are particularly high for African American and Hispanic men. They are 2 to 3 times higher in proportion to the general population. The amendment builds on existing guidance and focuses employment discrimination based on race and national origin. Title VII liability for employment discrimination is determined using 2 analytic frameworks: disparate treatment and disparate impact. Disparate treatment violation occurs when an individual of a protected group is shown to have been singled out and treated less favorably than others similarly situated on the basis of race or national origin. Discriminatory intent can either be shown by direct evidence or through indirect or circumstantial evidence. Example: you have 2 applicants, one white, one African American, with the same qualifications and suitability for the position. Both have similar criminal histories. The hiring manager selects and hires an individual. If one of the individuals falls under the protected class and did not get the job, he or she could file Title VII charges alleging disparate treatment. If facts are confirmed, then EEOC would find reasonable cause to believe that discrimination occurred. An employer is liable for violating Title VII when the plaintiff demonstrates that the employer's neutral policy or practice has the effect of disproportionately screening out a protected group, and the employer fails to demonstrate that the policy or practice is job-related to the position in question and consistent with business necessity. Disparate impact analysis looks to identify a company's policy and procedure, associated documentation, and how the policy was implemented, specifically looking to see if there are exclusions for criminal conduct that exclude a protected class. The employer must demonstrate the policy or practice is job-related and consistent with business necessity. Enforcement guidance. EEOC asks that you develop targeted screens by considering the nature of the criminal act and how it is relevant to the position you are hiring for, the length of time that has passed since the criminal act, provide an opportunity for individualized assessment on results of a consumer report, avoid having a neutral policy or practice that disproportionately screens out the Title VII protected groups that fail to show your policy and practice is job-related. Records of arrest. Records of arrest do not establish criminal conduct has occurred. An employer may make a hiring decision based on the conduct underlying the arrest if the conduct makes the individual unfit for the position. Example of relevancy: A school bus driver is arrested for DUI, or a daycare worker is arrested for child molestation. The conduct is relevant to the position. Example of no relevancy. If the school bus driver or daycare worker were arrested for disorderly conduct, the charge would not likely be considered job-related. Compliance. Two circumstances in which the Commission believes employers will consistently meet job-relatedness and consistent with business necessities are as follows. The employer validates the criminal conduct exclusion for the position in question in light of uniform guidelines of employee selection procedure. There is data or analysis about the criminal conduct as related to subsequent work performance or behaviors. Or, the employer develops targeted screens and the employer's policy provides an opportunity for individualized assessment. Individualized assessment generally means that the employer informs the individual that he or she may be excluded for criminal conduct within a defined period of time, provides an opportunity to show the exclusion does not properly apply to him or her, and considers the individual's additional information that shows the policy applied is not job-related or a business necessity. Consider the following with individualized assessment: the facts or circumstances surrounding the offense or conduct, the number of offenses convicted, the age of the individual at the time of conviction or release from prison, evidence the individual performed the same type of work post-conviction with the same or different employer, length and consistency of employment history before and after the offense, whether the individual is bonded under a federal, state, or local bonding program, rehabilitation efforts, ergo training and education. Ban the Box is a nationwide effort to remove criminal history inquiry from employment applications. There are currently no federal laws that clearly prohibit an employer from asking about arrests or convictions. There are currently no federal laws that clearly prohibit an employer from asking about arrests or convictions. But there are many state and local jurisdictions that have adopted laws regarding inquiries of criminal histories on a job application. The National Employment Law Project has a resource tool that lists states, city, and county jurisdictions where laws have been adopted to prohibit employers from asking about criminal records. Follow the link below to view this helpful resource. Best practices. Eliminate policies that exclude people from employment based on any criminal record. Train managers, hiring officials, and decision makers about Title VII and its prohibition on employment discrimination. Develop a narrowly tailored written policy and procedure for screening applicants and employees for criminal conduct. Identify essential job requirements and the actual circumstances under which the jobs are performed. Determine the specific offenses that may demonstrate unfitness for performing such jobs. Identify the criminal offenses based on all evidence. Determine the duration of exclusion for criminal conduct based on all evidence. Include an individualized assessment. Record the justification for policy and procedure. Note and keep a record of consultations and research in crafting the policy and procedure. For the full text of the EEOC enforcement guidance on the consideration of arrest and conviction records in employment decisions under Title VII of the Civil Rights Act of 1964, follow the link below. Thank you for viewing EEOC Guidance Puzzle Piece. Use this session as a building block for determination or review of your employment screening program.